All right, thanks very much, and we will proceed to comments. And our first group of three is Cy, Caleb, and Judd Campbell. Cy.
David, I really enjoyed the paper, and I've got two sorts of questions. Suppose I thought the framers had that they really believed in the rule of law, but I'm also able to show that 10 times during the Articles of Confederation, executives violated the law. Am I then to assume that they really didn't believe that, or it was just sort of high-sounding rhetoric? And then the second question is, when you get to the structural part of the Constitution, you say, there were these structural provisions that would conduce towards satisfying international law obligations. And I read that and I thought, why didn't you just say, like, there's structure here, but it's contingent upon the view that the House is more anti-international law than the Senate? That, of course, could change over time. So there's really nothing in the Constitution at the federal level that speaks to commitments to international law, and it just leaves it to the national government to decide whether to follow customary international law or treaties. There's just nothing there. It's almost like you're trying to concede something to the other side, but I don't know why, because I don't really see anything. I'm not saying that you're right or wrong. I'm just saying I don't understand the concession from your paper.
Yeah.
My question is about the title, constitutional discretion to violate international law, and in particular about the word constitutional there. So let's suppose that the Constitution, and in particular with respect to the president, which is a lot of the focus, I think, or at least a lot of the focus of the debate. Let's suppose that the Constitution doesn't make customary international law part of the supreme law of the land within the meaning of the Supremacy Clause, and doesn't give the president the duty to take care that it be faithfully executed. So suppose the Constitution doesn't itself give the president the duty to pay any attention to customary international law. I'm not sure it would follow that the president doesn't have a legal duty to pay attention to customary international law. It might just be that he doesn't have a constitutional duty to pay attention to customary international law. Right? Common law can be law also. If we think that customary international law is law in the sense that it can give rise to legal obligations for the United States, that the United States has a legal duty to follow, we might think that it takes some sort of domestic law to trump customary international law. And maybe Congress, within the limits of its enumerated powers, can pass such a law. But maybe without such a law, the president has a legal duty to pay attention to customary international law, unless one reads the Constitution as itself giving the president the power to disregard customary international law. So is the adjective constitutional in the title suggesting that the Constitution not only doesn't itself give the president a duty to follow customary international law, but itself confers power on the president to disregard customary international law?
Yeah, I want to follow on that. I mean, it seems to me that if we want to distinguish between small c and big C constitutionalism, you win me over on the big C constitutional argument. I read the document, I don't see it in there. Is it within the small c constitutionalism of the founding? Then we have to do a deeply historical analysis, whether it's normatively applicable now, including through judicial review or not. I don't know. But I'm skeptical of the historical argument, and particularly the treatment of Hamilton and Madison. Hamilton, you're citing a couple Federalist Papers, but not Federalist 15, where he's very explicit about the failure of the states to comply with the requisitions was unconstitutional. He says that. And I think he's thinking about it as illegal in a sense of not law that can be necessarily applied through coercive force, but law in the sense that the British Constitution was law. And so I think in these passages, he's really distinguishing between legal authority and practical authority, and he's almost solely focused on practical authority. That's the real problem. And I think that's Madison's view in the Jay Treaty debates. I mean, Madison, he thinks that the ability to fund legal programs has to be discretionary. So they actually work that out in an interesting debate a year before about whether or not to fund the mint. But then when it comes time for the Jay Treaty debates, that's not enough of a winning argument for him. He actually goes a step further and says any sort of appropriation that is required by the treaty does not become binding under international law until it complies with the domestic requirements of the particular state's constitution. In this case, the domestic requirements are that the appropriation must be authorized by both houses of Congress, and therefore I do not have an obligation under international law to vote for the appropriation because it has not become binding under international law. But the whole premise he's operating under is that international law is something greater than simply law, that it actually is operating in at least a small c constitutional sense, I think.
Okay. Cy, I mean, I think you make a good point that, and I guess probably a scope of evidence point, right? How much action inconsistent with statement leads to you to doubt the statements. And I think part of the response here is that we do have conflicting statements, right? So the statements don't all go in one direction. These statements that seem much more instrumental and not sort of instrumentally committed to international law, but international law is subject to national self-interest, both on our part and certainly we see it from large powers abroad. But then we also have these actions, and I think part of my response is these actions haven't been acknowledged, right? There's this sort of uniform account of how committed the founders were, and these contrary statements in conjunction with these examples, in conjunction with the fact then that we didn't speak about those during the constitutional creation, right? I think those three things together tend toward this argument. Now, I can't say they're conclusive, right? But I think you combine those things, and I come up with a fairly comfortable sense that it isn't as uniform as the traditional account has suggested. So as to these structural provisions and why not just argue that it was entirely left to the national government's discretion to violate international law, I think part of my answer is that I don't reject the conventional narrative, right? I do think it's incomplete, but I do think there was widespread concern for state violations of international law during Confederation and the foreign affairs problems that they produced, and we see constitutional responses to that, right? So there are efforts to bring us into greater compliance with international law, at least at that level, right? Transferring the authority, so much of the authority over foreign affairs to the national government alone is a response that tends toward compliance with international law. And then we get all these other things, right? Having the Senate as opposed to the House be involved, and talking about terms of the president and the Senate, et cetera, right? So I'm persuaded, in light of the conventional narrative and the statements and what the Constitution actually does and what they said in creating it, that there was this concern, there was this effort to bring us into greater compliance, at least vis-a-vis the states, right? I mean, I think again the motive was let's have these decisions made by a centralized government that will take account of national interests, and that's sort of how we're going to respond to what we've seen. So Caleb, I struggled with the title, and obviously not enough, but the other option was simply national discretion to violate international law, and I settled on constitutional and may yet change it, mostly because of the framing, right? In response to these arguments that the Constitution commits the national government to compliance with international law, and I think this suggests that there's at least not a large C constitutional commitment in this direction. But I think the point is well taken that while the Constitution may not constrain the executive, there may be other constraints or a sense that there needs to be authorization before this can happen, at least at the executive level. Now, I don't think that answers fully the national question, right? Because other actors may not need that sort of authorization. And so somewhere in the Constitution, there can be unconstrained discretion to violate international law, say in the Congress, right? And Judd, let's see. So one of the, I'm sorry, maybe a little bit more on Cato's point. One of the answers, and I don't think this is conclusive in any way, but under the Confederation, right, Congress was acting in essence as executive and legislature, right? So I think we have, again, some evidence of executive discretion to depart from international law during the period of Confederation. And again, no sense during the constitutional creation that seemed to be problematic. Now, I don't think that's conclusive in part because we created a whole new structure and we wanted a separate executive. And so once we create that separated power system, it's not clear that what we were doing in this unitary confederation system has a lot to say about this. But I think it is fair to point out that we did have some evidence of the executive power at least being tied to discretion to violate international law. Let's see, Judd, when we talk about the failure of states to respond, I guess I'm not entirely sure how that is relevant, right? Because that is the conventional narrative, and I don't dispute that. Right? There was concern that states didn't respond even to something that might have been deemed a constitutional requirement at the time, right? And that's the I think that point that they were violating even a constitutional or what might be perceived as a constitutional requirement just emphasizes this was a matter of concern. Right? But we solve that again by centralizing power. We don't need a commitment to international law on the national government's part to solve that concern. I think the small c constitutional part point is sort of more difficult to discount, and maybe I just need to be clearer, right, that I am sort of responding to these claims that the Constitution itself, sort of this document we created, embodied this sense of a commitment to, a substantive commitment to international law. And there still may have been sort of practical restraints. The evidence provided here suggests those practical restraints at least weren't absolute, right? Because the Confederation Congress was able to get around them. As to the Jay Treaty and the conclusion that the House need not appropriate, it seems to me that that's simply evidence, again, that there is not a constitutional commitment to comply with international law, right? Because that treaty obligation to appropriate or the need to appropriate in order to satisfy international law obligations is going to be international law regardless what the House does, right? And Hamilton's conclusion was the House is not domestically constitutionally constrained to act in a way that's going to lead us to compliance with that international law. So it seems to be, I've limited the evidence to sort of pre-constitution and constitutional formation. I think this is one example. I think the neutrality controversy is another potential example post-ratification where we see this understanding, at least arguably, that there was discretion to depart from international law.
So just I want to underscore a few points. I mean, the first one is that the case for the relationship between international law and the Constitution isn't made in David's paper. It's not one that he finds persuasive, but he's responding to it in a certain way. Now, its absence doesn't mean, in his paper, doesn't mean that the case doesn't exist, but I didn't think it appropriate to try to make the affirmative case here. There happens to be, I think Judd brought out a very nice example in what he said about Madison. Hamilton actually was much stronger and more straightforward in saying the House did, in fact, have a constitutional obligation to fund the treaty, and exercise the appropriations power. But Madison, too, in order to avoid that, actually had to work himself to a way to say, as you point out, that actually it wasn't a binding treaty until the House actually approved it, which was right in the face of the treaty clause. So it was a completely implausible position, but it was a position that he had to take. But it shows that he needed to preserve the idea of a constitutional obligation. So quite right. But so there's an affirmative case here. It's got textual elements. It has historical evidence of various kinds, very extensive, let's just say. David's paper is a very particular kind of response, bringing to bear a very particular type of evidence. And that evidence is about the behavior of the confederal authorities during the Confederation to the extent that they violated international law or they acted in a self-interested way. And there are, that leads by a chain of logic to the conclusion that the other evidence that there is a constitutional commitment of this kind must be wrong. Okay, so the strength of the paper has to rest on whether the evidence being presented on that point is persuasive or not persuasive. So there may be lots of other reasons to reject the claim that there was a constitutional commitment to international law, but the reasons that have been presented are the reasons that are in David's paper. And the question, I would think, is, are those particular reasons persuasive or unpersuasive? And I think as they stand now, they're unpersuasive. I don't think, notwithstanding some of the things that David said, I don't think that there's evidence either that the Confederation did violate international law, or that if they did it knowingly, or that other parties, other countries, charge the United States with violations of international law. Of course, it's very complex. There are moments of various kinds. Each one of those is very complicated. The whole story about the negotiation of the peace treaty and the American commissioners and so on, David brings out those elements of it where the American commissioners, the ministers, act in ways that seem in tension with certainly their instructions. Actually, it's really mostly about the fact that they violated the instructions from Congress to cooperate in certain ways with the French Ministry of Foreign Affairs. Not really about treaty violation, there's some issues there. But mostly, when the story is told in its fuller version, it turns out that the Americans, every time they threatened to take an action which could be construed as a violation of the treaty, they were reacting to what they perceived to be French violations of the treaty. So they never avowed a right to violate the treaty per se, but if Jay learns from Vergennes, the foreign minister, that actually the French are secretly speaking to the British and talking about possibly recolonizing together North America and dividing up the colonies, he says, with that information, Vergennes, he says right to his face, I'm going to Britain. I'm going to negotiate my own separate peace for the United States. Now, you could say, if you just quote that he says, I'm going to go negotiate a separate peace, that violates the treaty. But to say it violates the treaty without taking account of the context in which he said it and the reasons for which he said it and the justifications that he had, they never acknowledged. On the contrary, they denied always that they violated the treaty. And in the end, the French didn't claim that they violated the treaty either. So the treaty claim there is really, it may be the closest we get, but it doesn't constitute anything that could be established as a violation of the treaty. Certainly wasn't perceived that way in the United States. Okay.
Okay, so the next three people are Steve Sachs and me and Chris Green.
My favorite thing in the paper was footnote 52, which reads in full, note federal prize court, period. Note federal prize court, period. And I like that in particular because I think the federal prize court is something you probably want to grapple with. And in fact, courts and judiciaries in general, I think, should be a much bigger part of this paper than they currently are. Because I don't know the records of the pre-constitutional federal prize court as well, but certainly my understanding is that they applied the law of nations as law quite frequently, and that so did the early federal courts, and they're dealing with prize cases and related things. That's just all over the records. I don't think that in any way undermines your thesis. I think that as Caleb noted, law of nations could have been part of the common law that was to be used in federal courts where appropriate and potentially superseded in certain arenas by state or federal written law, and that could be perfectly consistent with the notion that there's no constitutional obligation that in all circumstances shields it from statutory abrogation, although it might in certain areas or might do so implicitly in certain areas. I have a paper on that topic I'd be happy to share with you later. But I think that in general, when you talk about the structural provisions, I think that's probably right. It probably was designed to be protected through structural provisions, but many of those structural provisions were judicial in nature. So you look at Article 3, you've got jurisdiction for ambassadors, jurisdiction in cases of admiralty and maritime jurisdiction, cases for alien diversity. These were the cases where international law stuff is likely to come up. There's also a whole field of internal international law. So the states, with respect to each other, were as foreign sovereigns, except insofar as the Constitution or statutes made them not so. So you had suits between states, or suits involving land grants from different states. There were almost always border disputes. Those border disputes were going to be governed by international law because there's nothing else to use to govern them. The Constitution supplied no rules. The states couldn't legislate that they owned more borders than they already had. And even ordinary state diversity often would deal with international law issues of personal jurisdiction or choice of law. And so a lot of the structural protections for the law of nations in the United States show up in Article 3 and not necessarily in Articles 1 and 2. All of which depends on this view that the law of nations could be law that federal officers, including judges, were supposed to respect and apply, just happened not to be constitutional law.
All right, well, I have two thoughts. One which is a friendly comment, and the other maybe a little less friendly. The friendly comment is this. I think one, if you're looking sort of for supporting evidence or complementary evidence, I think there's on the other side there's sort of a myth of the golden age of international law in the 17th and 18th centuries, where you had this outpouring of writing by people like Grotius and Wolff and Vattel, and these people were not just law professors writing for themselves, but they were writing quite overtly for the kings and princes of Europe. They gained diplomatic and advisory positions, and for example, the great Swedish king and military leader Gustavus Adolphus was said to sleep with a copy of Grotius under his pillow during his campaigns, and this is played into a myth that the American founders must have shared this reverence for international law in order to sort of be part of the system. And I'm not suggesting that David's paper takes up this myth, because I think it's much more realistic. But I think there is this myth behind that supports the idea of this constitutionalizing of international law. I think this myth is just false. And I think your paper goes a ways to showing that. But I think there is more you could say, including that the actual practice of international law by nations at the time, as some of your quotes from the Federalist Papers that I really like shows, was quite realistic in the sort of modern sense of driven by national interests and so forth. And so to fit into the 18th century system of international law, you didn't need a constitutionalized international law system. You just needed what you're suggesting, which is control at the federal level to decide when to violate and when not. And that was exactly what all the other nations in the world had. And why would we put ourselves above what are more constrained than other nations were? So I think showing that side of it really reinforces what your sort of the narrative that you're trying to advance, sort of in opposition of this of the Golden Age myth. So now my second comment, which you could construe as less friendly, is really, I guess, a question, which is what is then though the cash out value of this claim? At least in terms of sort of the mainstream of foreign relations law, I think it's generally accepted that Congress has the power to violate customary international law. That's heavily implied by the Charming Betsy case and the embrace of that of that case and that rule. And it's generally accepted that Congress has the ability to violate treaties. through the later in time rule, which is certainly mainstream of modern law and has been argued very strongly by people such as Julian Koo to have been part of the original understanding. And so beyond that, I mean, I accept that though your view would support that power of Congress, but beyond that, then what? And so to maybe defend a couple of the dogs that I have in this fight, because although perhaps David is if David's the primary target, I feel at least a little bit the secondary target of this paper. Two propositions. One, that there is a strong version of self-executing treaties, which makes self-executing treaties operate as law at the federal level, at least until the time that they're broken by a later in time statute. And secondly, that the president, absent contrary authorization from Congress, would have not just a common law, as Stephen Caleb suggesting, but indeed a constitutional duty to take care that the laws, including international law, are faithfully executed, again, subject to a contrary direction by Congress. And I guess I don't feel that anything in your paper calls into question either of those propositions, because those propositions rest on not general propositions about sort of how the framers felt, but rather about particular conclusions about particular language. So, I mean, I'm not sure whether this is a methodological question or just a question about where you think this is going, but at least methodologically, I don't see how conclusions at the general level of your paper are going to cause me any worry about some of my particular conclusions. All right, that's only two.
Okay.
Chris Green.
So I had a couple quick thoughts. One is, I wonder what the relationship is between Article 6, Section 2, the Supremacy Clause, and Article 6, Section 1. So Article 6, maybe I missed or forgot a reference to that, but Article 6, or Paragraph 1, all debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. And I mean, this is not talking about states, clearly talking about the federal government. Section, Paragraph 2 is Supremacy Clause, clearly structural, and talking about states, state judges being bound, but I guess I wish I'd brought a copy of the Confederation, but with Articles of Confederation with me. But the Declaration of Independence at the end says we've got power to conclude peace, contract alliances. It seems like they have the power to undertake obligations upon themselves. And if Article 6, Paragraph 1 says it's as obligatory, it seems like, I mean, at the minimum, Constitution is saying, well, we're not trying to just get out of our obligations with this Constitution thing. I mean, maybe that doesn't get you the whole way. Second thought is that I wanted to kind of draw a connection between some of the things that David was saying and the earlier discussion this morning about the relative importance of what we say and what we do. So it's clearly possible that you can articulate principles inconsistent with those on which you're acting, Dred Scott notwithstanding. The more important is what you say, not just about like whether you're violating a treaty, but what you say about your discretion to violate a treaty. So it's statements at that principled level that are going to be the most important. Actions are relevant, but the coin of the realm would be actual statements about the principle.
All right, so let me try to respond quickly first to David's comments. I don't know that it's fair to say that the American peace negotiators only departed from the spirit or law of the Treaty of Alliance when they felt like France was doing so. I think of something like the separate article, which doesn't seem motivated by a sense that France was maybe negotiating independently with England. The separate article was to secure, sorry, my memory's a little bit a particular border with Spain, right? And so I don't think you can uniformly say, at least, that the negotiators were responding to French violations. I also think it's not fair to say that the French never complained, or that they only complained because the American negotiators had violated their instructions to Congress. Certainly Vergennes starts with that, right? You've gone beyond what Congress has authorized, but he goes on to say that this is also a violation of our treaty. Steve, I think you're absolutely right with the judiciary, and the judiciary being a good example of structural ways in which we were tending toward compliance. Part of the difficulty, I think I mentioned briefly, right, that this sort of continuous consensus of a need for a federal judiciary to deal with things like prize cases, cases where the law of nations would apply, demonstrates this desire to some level of compliance with international law. And then my focus is, but see these examples of discretion, right? So I clearly have not laid out all the examples. There are many pages of examples of situations where the national government was complying with international law, consistent with these claims of a constitutional commitment. And my goal has been to say that's not the whole story, right? So I have not told that whole story, but I think I do need to add the part about the judiciary. Let's see, Mike, so what's the cash out? And this actually goes back to a comment David made as well. This paper is limited in the sense that I'm only taking on really one primary piece of evidence that's used to claim a constitutional commitment, right? So there are other reasons, other arguments that have been made in support of a constitutional commitment to international law. One of those arguments is the conventional narrative, and I think that appears in self-execution under the Supremacy Clause. It appears in broader claims like David's to a general constitutional commitment. In the Take Care Clause, right, this conventional narrative at least colors the sense that these specific provisions were designed to secure national compliance. And so I don't think the payout is a full refutation of the arguments for constitutional commitment. I think the payout is more narrow, that this evidence that's used to support a constitutional commitment in these various forms is not the complete story, right? And so I think at the end of the day, the argument is these claims are overstated, right? They don't take account of this other evidence, both the evidence of violation and the lack of concern for that in the constitutional process. I also think the payout extends beyond how I framed this paper. I mean, I think one of the general themes you will hear in international law and the foreign relations law context is this conventional narrative supporting a general sort of priority for international law, right? So it's not just in the context of arguments for a constitutional commitment. This narrative, I think, is invoked quite generally to suggest a prominence for international law. And so, again, I haven't framed the paper in that way, but I think there is some value to highlighting this evidence and suggesting that, again, that the narrative is incomplete. Oh, I didn't respond to Chris, sorry. So, you know, I don't know enough about Section 1 of Article 6 to know what it was targeting, right? If this was trying to ensure that congressional debts to soldiers, or you know, for supplies during the war, we were trying to preserve our commitment to those, or whether it was a sovereign debt provision. To the extent it is a sovereign debt provision, it does suggest that here is one substantive commitment to comply, at least retrospectively, right, with contracts we've made retrospectively. So I simply need to look at that more. As to the statements versus actions, I think my theory is colored by how discussions of international law proceed generally and sort of trends in international law argumentation, right? I think historically, for example, for customary international law, there was more focus on what states actually did to identify whether a norm was in fact a norm of international law. And there's been a trend that has met resistance to look more at what states say at the General Assembly, for example, right? How are they voting on General Assembly resolutions, even though they're technically not binding, right? And we can use that as evidence of what is actually international law. And so part of it, I think, is colored by my theory of international law, that it's more, the evidence of action is part of the definition of customary international law. It's arguably part of the definition of what constitutes a treaty, because you have to take some action to be bound, right? And so I think international law, at least historically, tends to be based more on action, and I prioritize that in this assessment.
So on that last point about the importance of statements, of normative statements versus actions. So when you look at the records of the Confederation, including the records that David is relying on, they are literally filled day by day, day after day, with reports about international law problems that have arisen and the efforts of the Confederation to comply with international law, a constant worry. And even as I said, the example I gave with respect to the ratification issue, Congress they were constantly aware that if they had made the promise to ratify, they did ratify. Even when they didn't ratify, it was a constant subject of discussion and worry. In the case of the French treaty, the Treaty of Peace and the preliminary Treaty of Peace that David talked about, they were absolutely meticulous to insist. It was called the preliminary treaty, followed then by the definitive treaty. It was tied to the French preliminary treaty. It didn't take effect until the French had signed their preliminary treaties along with the Spanish. Everything was done to make sure that they stayed within the obligations of the treaty. And these are the cases that David's citing as evidence of their violations. So it just couldn't be more pervasive that every statement that is made, there aren't any contrary statements, is about the importance, the essential necessity of complying with treaties and the law of nations. So that's one point. Another point, I want to just say something in response to Steve. I'm not sure what the significance of the point that you are making. So the president has a duty to faithfully execute the laws. That includes the law of nations, but the law of nations is not constitutional law. You said it's some other kind of law. And I'm not sure what turns on whether it's constitutional law or it's some other form of law, if the question is that's being addressed is whether or not there's some kind of a constitutional commitment towards compliance with the law, at least by the president in that context. So, and we have, again, we have hundreds of statements during this period, in the period after the Constitution and the period that Judd was referring to, on all sides, whether it's Republicans or Federalists, asserting the president's duty to comply with the law of nations as part of his duty to faithfully execute the laws, or as part of his commander-in-chief power, and so on. And also similar statements with respect to Congress's powers, because many of them invoke the law of nations, the treaty power. So what's a valid treaty? Well, how would you determine what a valid treaty is? Well, presumably the original public meaning of treaty is as it was defined in Vattel or something. And that's very common throughout this period. So those statements are present. And a last point is that with respect to the instrumental character of some of the reasoning and justifications, it's a little hard to understand who would think that instrumental reasons wouldn't be a big part of why anyone would argue for the importance of compliance with international law or any kind of law, or indeed for any kind of policy. But those are almost always and pervasively connected to statements of invoking other kinds of ideas, whether we can just say moral or reasons of justice and so on. So they're intermixed together in complicated ways everywhere and pervasively. So to point out that there are also statements that assert instrumental reasons as a way of undercutting the commitment to international law, it seems to me to be misguided.
All right, well, we have about 8 minutes to go and another troika to get through, so I think I could encourage everyone to have the questions relatively short. The Troika is Will, Sarah, and Richard Ray. So, Will.
So I'm puzzled by the whole narrative here about states and how they were concerned about state violations, because you sort of lay that out as a concession, and then I don't understand where it goes. So under your theory, does international law bind states, and if so, why? Because I take it you think it's not constitutional law under the Supremacy Clause. At least customary international law doesn't seem to occupy any of the categories under the Supremacy Clause. So I would assume that under the 10th Amendment, states have the prerogative to pass statutes in violation of international law too, if they want to. Now that, I think you're going to say, well, there are structural guarantees that make sure the national government has the power to force states into compliance. And then I would have expected you to say something about, does that mean that the treaty power is plenary, that there are no, or something about the limits to the treaty power, which is a subject of great contention now? Does that mean that Missouri versus Holland is rightly decided? And that Congress can pass, statutes, or maybe even broader than that, I'm not sure. Is there some sort of plenary power to bring states to heel on international law questions? And does that have some implications, maybe even for the Jay Treaty question? Is there some duty to comply with international law obligations and treaties that the national government has effectuated? And I guess I would have thought that's what the point of laying out the state thing was for, and sort of where did that go?
It seems to me that this project is about adding more facts to an account to get a better understanding of what the founders may have thought or may have not have thought about their commitment to international law. But I sort of saw this in the paper, but I think that as a reader, I'd like to see it come up more explicitly or in a more developed way, that this was maybe a particularly up and down and tenuous time for the United States internationally, and that they were constantly in for some part of the years, they were actively fighting other countries and relying upon other countries to come to their aid. So any close account of the actual fighting the revolution is like, are they sending the guys? Or are they not sending the guys? Have they arrived yet? Do they have the beef? Do we have the money for the beef? Are they going to give us the bullets? Or are they not going to give us the bullets? And then even after the fighting ended, there were these debt obligations, that they're trying to jockey, and then there are also these Western boundary arguments that are going on, disputes in other ways. So I just wonder about the possibility, maybe it's just very difficult or it might be impossible, to lay out enough facts to understand whether the founders were expressing in any statement or any action an actual commitment or lack of commitment, or if they were really in that particular moment trying to say, I hope that France is reading this and knows we really care about them so they come to our aid and save us, or they didn't deliver that ship when they thought that they would and they're taking this in totally direction and maybe they're going to invade us. So I guess and to summarize, I just want to say, it seems like what you need is a phenomenally nuanced factual account of all kinds of things that are happening at the time, even just internationally. Or you kind of have to abandon that altogether because that's just too difficult to really account for all who wrote it and what was their public position and who do they hope was going to be reading it, who do they think was going to be reading it, or what did they say and what did they want on that day. Or you just abandon it, and what you're left with is constitutional structure, because that is the thing that got enacted and written down and doesn't depend on any given sort of jockeying for international position or resources or defense or something.
Richard.
Oh, just very briefly at the end, great paper, I enjoyed it very much. I guess if you've shown that a certain rule has been not followed, it's been violated, as you put it, repeatedly or in a big important way, one takeaway is that there's discretion to violate the rule, which is what your title asserts. But another possibility is that the rule is actually more nuanced than it may initially appear. Maybe it can be, its application can be avoided if there's a sufficiently large countervailing reason, or I think as David was saying earlier, maybe the rule is one that allows for incremental change because the rule follower is also a rule maker. As you said, this is a practice-based system of rules. And so I just wondered if methodologically it could be the case that the answer to David's second question, the point of finding this history might not be to say, oh, we have discretion to violate the rule, which kind of sounds like the rule doesn't exist at all, but rather that the rule is just a little bit more complicated and textured than it may have initially appeared.
Okay. Will, I'm not sure I'll get through all those questions, but so this part of the answer, I think, is the focus on what this means for the nation and not for the states, right? And there are a number of other things aside from, I'm not sure what the national government was doing in the period of Confederation bears as much on how we think about the relationship between the states and international law post-ratification. I do think part of the reason the focus is there on the states is because, again, that is the conventional explanation for a lot of what was done. And because that was such a prominent concern, we do get a real focus on the states, both in the constitutional text and in the ratification process, right? So you get this from the Supremacy Clause, right, this specific reference to, and state judges have to follow this, right? And no mention of federal judges, right? We certainly interpret it that way, that it binds them as well, or they're bound in another sense because this is created by the organ of which they're a part. But a lot of this, right, generates response to the states. But I think there are other considerations that have to be brought to bear to answer the question of what this ultimately means for the states, right? Is the treaty power plenary? I don't know that this alone would answer that question. I think you have to consider things like, what did the founders think constituted a treaty, right? And certainly it was war, peace, and commerce, right? Things that weren't areas of traditional state regulation, at least post-Constitution, when we say, Congress, you get the foreign commerce power, et cetera. Again, I just think there are other factors that we have to bring to bear other than this history, and that my focus on national discretion doesn't permit sort of bringing all those things in to talk about what this means for the states. So Sarah, I think that's a really good point, that this was a very tenuous time, and it was a time when we were highly dependent on France primarily. And I'm not sure which way that points. I mean, in some ways the story could be, we were so dependent on France, we really had to comply with our obligations, right? But you see us very shortly after, and while still owing France a lot of money, departing from, or at least the spirit, I think, of our treaty of alliance with France, right? And so I think that sort of tenuous time story may strengthen the case. Now, not inevitably, right? But I think the story can be told in that way. Let's see. I think also relevant to the point is that it wasn't just during the period of revolution when this stuff was going on. It's also in the period of constitutional creation when there is a lot of talk about the significance of violations of international law, right? And there's a lot of talk about the failings of the Confederation government. And so things highly related to this question were being discussed and were of great concern, but we don't get that additional discussion about what the Confederation government was doing with regard to international law. And so I don't think that depends so much on sort of the tenor of the times, right? I think that is independent evidence that, again, isn't affected by that. Richard, so this issue that the rule may be more nuanced, I think that's an easier argument to make in the context of the law of nations, right, which isn't codified. I think it would be hard to say with regard to these treaties, and when you have the U.S., for example, saying France's exclusive rights to the fisheries doesn't also prevent us from fishing, or we still want fishing rights, right? Doesn't lend itself well to say that the treaty was just more nuanced than we suggest, or that an unconditional an unconditional most favored nation clause, right, really is a conditional most favored nations clause, right? I don't think the treaty easily permits that sort of nuance. With regard to customary international law, I think there is more room for making that argument because certainly customary international law permits change, anticipates change, and the change occurs by way of violation initially, right? And so I think one response to this is that the United States was involved in this project of changing international law, and so it was within the scope of the international system. I think that argument, though, doesn't work for a number of, is difficult for a number of reasons. One, I don't see any effort on the United States' part to try and change international law in this way, right? It didn't seem to be a project of changing what the Law of Nations said. It seemed to be more a project of this is how we're going to do it. And again, we were still sort of demanding that other countries adhere. If they sort of signed on, we were not uniformly avoiding mandatory ratification, right? So it doesn't look like a project to change international law. Even if it were, I think we'd still have to say it was a violation at the time, right? Ultimately, it's successful. Maybe 50, 60 years later, it was successful, right? But I think, for example, of the recent Bush administration argument that preemptive strike was part of customary international law, right? And the UN and countries around the world responded by saying, no, self-defense does not include preemptive strike, right? If this were to develop, in the next 50, 60 years, we adopt preemptive strike, I don't think we would go back and say the Bush administration was acting consistently with international law, right? These were efforts consistent with customary international law. I think looking at them fairly at the time the actions occurred, they have to be characterized as an effort to stretch international law that were not accepted at the time.
Now, 30 seconds to wrap us up.
Okay, well, very, very briefly, just because I like Will's point so much. So it goes back to what a treaty is and what the original public meaning of a treaty is, and which is otherwise not qualified in any way. And of course, to import from context a limited set of treaties would at least depend on historical accuracy. But in fact, when you look at the treaties during the Confederation, they went well beyond the described list into areas which were extraordinarily sensitive from the state point of view and led to great resistance and was part of the grounds for why the states weren't complying with treaties, which led to the adoption of the Constitution, the Supremacy Clause, and an unqualified treaty clause. So when you take that context, it looks like the conclusion is Missouri versus Holland is rightly decided.
Well, we'll have to end on that note. Thanks very much.
You agree.